afternoon, everyone. Hope you've had a drink and some break. My name is Jujing Liu. I'm a legal director at the IBA Piper in London. For the last 14, 15 years, I've been an international arbitration practitioner specializing in commercial disputes and international arbitration. I have the wonderful pleasure today of joining the IEC's Women in Arbitration event, and I'm delighted here to have the opportunity to speak to you about a very interesting topic, at least I find it quite interesting, in challenges to arbitrators. I hope to speak for maybe 45 minutes, 45, 50 minutes, and I'll leave some time for questions at the end. But if there are any burning questions that you have as I go through my slides, please feel free to put your hand up and we can address your questions and as and when those thoughts come to the front of your minds. So this is a summary of what I'm hoping to cover. In the interest of time, we probably won't have time to go into everything in detail. But in the first, I'm hoping to have a look at the challenge against arbitrators and give you some broad context. And then I will say a few brief words about those two concepts, independence and impartiality, their definitions and how they form the framework of a challenge against an arbitrator on those bases. I will have a very brief look at the IBA Guidelines on conflicts of interest in international arbitration. And you'll hear me talk about it in more detail later on, but this is a very important piece of soft law instrument, which is heavily used and widely accepted across the world in international arbitration. I will then talk briefly about how parties and legal advisors come to a decision as to whether to challenge a particular arbitrator, and how to actually deal with the challenge in institutional arbitrations. Then I will briefly talk about some of my own tips for dealing with, for making the challenge, but also responding to a challenge. And I will briefly discuss the role of national courts, particularly the English courts, in looking at challenge decisions and challenge applications, and to give you a list of recent court cases which are particularly important in this area. So moving on, first of all, a little bit of a context. Now, as I said, today I'll be focusing on challenging or applying for the removal of arbitrators on the basis of the lack of independence and or impartiality. I'll look at these two concepts, as I said, very shortly, but due to time constraints, I won't be covering other grounds for challenge an arbitrator. For example, on the basis that they don't have the experience or qualifications, or that they failed to conduct the arbitration proceedings, or failed to make an award on reasonably speedily, or perceived incapacity. All of those are absolutely grounds for applying to have the arbitrator removed. But this is not going to be the focus of my session today. So what I'm hoping to really discuss is, and I won't be discussing two other aspects of challenge that we very commonly come across in day-to-day practice. The first of those is jurisdictional challenge, whether pre or post the award, the issue of the award, on the basis that the tribunal lacks jurisdiction to determine the dispute. And the second thing I won't be covering in great detail is challenge to or applications to disqualify arbitrators in exit proceedings. I will focus primarily today on commercial arbitration because exit has its own very distinct procedure. And it's a body of, and has its own body of relevant law and jurisprudence, which we won't have the time to go into, I'm afraid. So what are the key takeaways? And I want to get these out of the way. So the key takeaways. The key takeaways for today's session. I want to introduce sort of some of the key legal and soft law guidance framework for challenge arbitrators in an institutional context. And this is, and I want to give you a good starting point. So I want to introduce the legal and soft law framework for challenge and arbitrators in an institutional context, providing you with a starting point should you come across issues that may cast doubt on your arbitrator's impartiality or independence. I very much want to impress on you that when deciding whether to make a challenge application is a very important decision that is not to be taken lightly, and one that may have very serious implications for the case and for the arbitration as a whole. I also want to flag that it is possible for a party to waive its right to object to an arbitrator, impartiality or independence, if the party fails to act in a timely fashion when they are made aware of certain information, so those are the three things I think it would be very useful for you to take away. So moving on. Conflict issues in arbitration generally stem from the fact that there is typically a web of relationships, whether past or present, between the arbitrator on the one hand and the parties, or one of the parties, and their advisors or related parties. It is the IBA Guidelines on conflicts of interest very much seek to give practical examples of how these relationships can, depending on the facts of the case, give rise to justifiable doubts as to the arbitrator's independence and impartiality. But I think before we get into how and why, whether to make an application to challenge, I want to look at the various patterns of facts that may give rise to doubts as to whether an arbitrator is independent or impartial. Now I've put on this slide a triangle with the arbitrator at the very center and the other stakeholders and parties around them. And I've listed in bullet points the various fact patterns that may give rise to concerns around impartiality and or independence. At the very top, and this is clearly the clearest and most egregious example of a conflict, and that is financial profit. Where the arbitrator owns shares, for example, in one of the parties or one of their competitors, or it could happen where the arbitrator may be on the board of one of the parties or their competitors, and this is obviously a very clear example of a conflict. Then it's also possible for the arbitrator to have a relationship with one of the parties. The arbitrator himself or their law firm may have acted or advised one of the parties, or continues to act for one of the parties in the dispute, or may have an underlying commercial arrangement with one of the parties. The arbitrator or their law firm may have acted for the opponent of one of the parties in an unrelated matter. And this is particularly, I think, an issue for large law firms with many, many offices around the world, with a very complicated sort of structure of governance and teams in various practice groups. And then you can also have an arbitrator who has been repeatedly appointed by one party or their counsel in multiple arbitrations. And this is, again, something that comes up very often in practice, and it raises issues really about whether the arbitrator can justifiably continue to conduct the case as an independent and impartial arbitrator. And then there's also the issue of personal relationship, whether it's a friendship or social connections. And there have been some cases where arbitrators have been challenged or even removed on the basis of friendship with counsel or parties. The third category is instances where the arbitrator is alleged to have prejudged issues. So this may happen where the arbitrator sat on a tribunal which has considered the same issue or a similar issue, potentially for one of the parties or in a completely unrelated case. It could also happen where the arbitrator has expressed public views, whether by writing certain articles or speaking at conferences like this on a particular point, and that is alleged to have certain significance to issues in the arbitration. Lastly, there may be conduct issue, what I call conduct issues, which could give rise to concerns. For example, the arbitrator communicating with one party behind the back of the other party. You may have the arbitrator making a series of what are perceived as unfair procedural decisions consistently directed at one party, which could actively prevent a party from properly presenting their case. There may be some arbitrators who are quite used to expressing views about the outcome of a case before they have heard the substance or the evidence from the parties. There may be it's quite possible. Also quite possible, and this happens in real life, and we've seen some cases as well. There'll be instances where arbitrators engaging less polite or even angry exchanges with a party or its counsel. This is more likely to happen at a hearing where the arbitrator may be considered to have displayed partiality by effectively acting as an advocate for one of the parties. So all of these, I think, will give you a flavour of the range of issues that come up in an arbitration, and some of the factual patterns that may or may not support an application for a challenge. Why are we actually talking about this topic? This is because it's a fundamental principle of international arbitration. That every arbitrator, whether they're acting on their own as a sole arbitrator or they're part of an arbitral tribunal, they must be impartial and independent, not only at the time of accepting their appointment, but also throughout the entire course of the arbitration proceedings. And this principle very much stems from the fact that as court judges or judges in the court system, arbitrators make binding decisions disposing of the parties' substantive rights, and it's only right that they do this in an entirely independent and impartial manner. Obligations of impartiality for arbitrators come from a number of sources. There are national legislation which set out very clear, usually very clearly, the obligations for arbitrators to be independent and remain so. Institutional rules also provide for impartiality and independence. For example, here we are in the AIFC court, and I've looked quickly at the IEC rules. Article 9 of the IEC rules deals specifically with the independence of arbitrators. 9.1 states that every arbitrator must be and remain independent and impartial. 9.2 states that before they're appointed, a prospective arbitrator shall disclose to the party proposing to appoint him any circumstances of which they're aware that may give rise to justifiable doubts as to their independence or impartiality. So this is, and this type of wording based on justifiable doubts is actually very common across all of the major arbitral institutions. And then we have the soft law, what we call the soft law instruments, for instance, the IBA Guidelines, which the parties very, very commonly adopt in their arbitration internationally. So before we actually delve into the details, why is it important to be clear why this topic is important and why it matters for us as arbitration lawyers and parties to an arbitration? As many of you will have experienced, usually at the outset of the proceedings, during the process of appointing an arbitrator, that can be a very time-consuming process. And if there are issues with the arbitrator's independence, those concerns are best raised at that stage. And we'll come to a discussion about why. Secondly, under both national law and most institutional arbitration rules, after the arbitral tribunal has been put in place, and every arbitrator, an arbitrator may be challenged if circumstances come to light later about their involvement and their independence. And that is something, I think, as one of the speakers mentioned this morning, an arbitrator has a continuing duty to review their position on independence and impartiality. And the same goes for the parties and their counsel. This is a matter that needs to be kept under regular review. And then an arbitrator's lack of independence or impartiality can be grounds for challenge and award under the New York Convention and the relevant national law. And that is precisely, all of these are reasons why, as counsel and as party representatives, we really should keep a very close eye on information that emerges regarding the arbitrator and his relationship. The last point I want to make on this slide is, as you can see on the slide, there is, over the last 10 to 15 years, there has been a bit of a convergence in international standards, and most major jurisdictions and institutions now apply broadly similar rules, for example, i.e. an objective rule of justifiable doubts regarding an arbitrator's independence and impartiality, with quite similar approaches to the standard proof requiring justifiable doubts rather than absolute proof. Nonetheless, I think some differences do still exist among national laws in the treatment of the issues of impartiality, and it's important to check those rules and guidance when you're considering an application. So next, I want to have a quick look at these two concepts. What do these terms actually mean, and how they are distinct? There are, broadly speaking, conceptual differences between these two notions. Independence looks at the arbitrator's relationships, as I mentioned earlier, with the parties, whether they are financial or otherwise, irrespective of whether the arbitrator's state of mind suggests bias. Whereas impartiality focuses on the behavior or the state of mind of the arbitrator, and whether the arbitrator can actually decide the case free from outside bias. In practice, these two terms are often used interchangeably. Institutional rules contain slightly different formulations often, and I think it's fair to say that these two concepts are complementary and both go to achieving the same goal, which is to ensure that the arbitrator is able to look at the merits of each case open-mindedly, fairly, and objectively. The standard is also is very typically the appearance of bias rather than actual bias, whether there are justifiable doubts rather than actual proof that an arbitrator lacks these qualities. And broadly speaking, we have a sort of a framework when it comes to sort of arbitrator challenge applications. There is broadly speaking, the framework of laws, institutional rules, and soft law guidance that may have a bearing on your specific challenge application. National legislation, and all of them may provide slightly different standards and obligations for arbitrators, and they together form the core of that framework, as I said, that is intended to apply to an unknown number of situations. The key underpinning of these rules is the duty of arbitrators to remain independent and impartial towards both parties throughout the proceedings. and to maintain an appearance of neutrality. The concepts of independence and impartiality do not both appear in arbitral rules and national laws. However, a combination of these concepts and slightly different formulations, as I say, will almost certainly apply in almost every case. There are other codes of ethics that might be relevant to a challenge application. For instance, the ABA's Code of Ethics for arbitrators in commercial disputes. The Singapore International Arbitration Commission has its Code of Ethics for arbitrators. And I think probably most well-known example is the IBA rules on conflicts of interest, but also the IBA rules of ethics for international arbitrators, and those are all of the sources of obligations and standards of neutrality and impartiality that may apply in your case. Next, I want to have a very quick look at the IBA guidelines. The IBA guidelines on conflicts of interest in international arbitration were prepared by the IBA Arbitration Committee, and they were adopted by the IBA Council in 2004. So they have been in place for the last 20 years. And these guidelines have, I think it's fair to say that they've gained very broad acceptance within the arbitration community, and they're now recognized as a leading set of standards that are expected to apply to our impartiality, consideration of impartiality and independence for arbitrators. And I think they're very widely adopted by parties, certainly in the arbitrations that I've had experience of. As I say, these guidelines were first adopted 20 years ago. They were revised about 10 years ago in 2014, 2015, and an updated version of the guidelines have just been published earlier this year. The guidelines broadly contain two substantive parts. The first part contains very general standards regarding impartiality, independence, and the expectations of disclosures that arbitrators are expected to make. Each standard is accompanied by an explanation which brings the standard to life. There's a second part of the guidelines which contains what I call application lists of various colours, 3 colours principally: red, amber, and green. These lists, which take the form of, as I say, a traffic light of these colours, with red being, absolute no-nos, amber being slightly dubious, that arbitrators may be required to disclose, and green representing matters and facts that do not cause concern ordinarily. Together, they address a range of situations that are likely to occur in arbitration practice and guide what type of action that should or shouldn't be taking place. The guidelines, I think it's fair to say, the guidelines themselves are quite detailed, and they include a very useful general recommendation on how these standards should be applied, cautioning against reading and applying the guidelines as primary law. They are, I think, it's a very important, I keep saying, but it's a very important instrument in international arbitration. And to my mind, they're a full topic in themselves and probably deserve a separate session. But in the interest of time, this is all I'm going to say about the IBA guidelines for now. If any of you have any questions about these guidelines, I'm very happy to have a conversation after the session. Next, on this slide, I've summarized the who, when, and how of challenges to arbitrators. And hopefully they give you an overview of how these applications are made in practice. Firstly, who. These challenges to arbitrators are typically a party-led process. However, the independence as I've noted earlier, the independence and impartiality of an arbitrator can also be raised in courts. for example, in the context of seeking recognition and enforcement of an arbitral award. But it's typically, and in some jurisdictions, it is considered contrary to national public policy to grant recognition and enforcement to an award where an arbitrator was not independent or impartial in the proceedings. In terms of when, typically, as I said earlier, the facts and circumstances leading to a challenge arise usually at the very start of an arbitration, when a party becomes aware of the identity of an arbitrator or an arbitrator candidate. The arbitrator candidate would typically make disclosures about their interests, about their relationships and experience. And it's important at this early stage, to consider whether you need any more information from a particular candidate or the arbitrator, and whether there are potentially grounds for a challenge, for a removal, for instance. As we will discuss a bit later today, there is typically a period in which objections can be made, usually through the institution or in ad hoc arbitration against the arbitrator themselves. Otherwise, if there has been delay on the party's part, then the opportunity to challenge may well be lost. Of course, parties need to bear in mind the possibility of further information coming to light, as I said earlier, during the course of the proceedings, which may call into question the arbitrator's independence and impartiality. This is why it's very important to always keep a close eye on developing situations and information and developments that come to light that may cause you to have doubts about the arbitrator's independence and impartiality. Having said that, as I will sort of explain a bit later on, it can be gradually more difficult to mount an arbitrator challenge as the case progresses, certainly towards the very end. The sort of the more advanced the arbitration is, the more difficult or sort of it may be to make a challenge, and there may be legal as well as other practical considerations that sort of dissuade you from actually making the challenge. But we will discuss these a bit later on. In addition, there are also post-award challenges, which I've talked about in the context of recognition, enforcement actions seeking recognition and enforcement of the awards. In terms of who decides, who decides an arbitration challenge will very much depend on the parties' agreement. For instance, whether they have agreed to institutional arbitration, or whether they are currently involved in an ad hoc arbitration. National courts typically retain a power to decide challenges to arbitrators in certain circumstances. In institutional arbitration, for instance, arbitrator disqualification challenges are typically heard by the institution's court. So this can be whether this is ICC or the LCI or the AIFC court, or a special committee or body convened for that particular purpose. For example, in Hong Kong, this is decided by the Proceedings Committee of the HKIC. In ad hoc arbitration, it may be that the unchallenged members of the tribunal will hear a challenge. This is contemplated, for example, by Article 13 of UNCITRAL Model Law. If a challenge is not successful before the unchallenged arbitrators, then a further challenge to a national court or other authority may be possible. Equally, in an ad hoc situation, it's possible for an appointing party, an appointing authority agreed by the parties or specified in the national legislation to decide a challenge application. For example, again, this is set out in Article 13 of the UNCITRAL arbitration rules. And finally, a national court, again, in ad hoc situations, can decide a challenge application where no other procedure has been agreed. An example of this would be Section 24 of the Arbitration Act 1996 in England and Wales. But this requires the parties to have exhausted any other agreed procedure before an application will be entertained by the English courts, as you would expect. Then I think we come to the process of actually deciding whether, and the often a very difficult decision, whether to challenge or not to challenge. And I've listed on this slide a few considerations or questions that may be useful to ask ourselves and explore with the clients before we decide which way to go. There are the initial matters, which I've covered already in terms of who, when, and how. Timing, is it too late to make a challenge? Or is the opportunity to object already lost? And then thirdly, I think crucially, do we have sufficient grounds, more than passing something that we often say in England, something, enough to pass the red face test? But it's also, I think, important to consider the downsides at this stage, the downsides of an unsuccessful challenge. And there will be very, I think, serious ramifications if this is not treaded carefully. So what, happily, if an application has been successful, happily the parties, for your client, a couple of things are likely to happen. Then will be a replacement of the arbitrator. Usually, that replacement arbitrator will then be appointed in the usual manner as before. Although I think in practice you're always aware that there is a risk that a less favourable arbitrator may be appointed after the challenge, and it may or may not be your client's interest, even if the previous challenge has been successful. And it is also possible, I think, under some institutional rules, it's also possible for the arbitration to proceed with the remaining two arbitrators. And this may or may not happen with your arbitration, but if it does happen, it's going to have some very interesting some impact on the dynamics of the tribunal. And that is certainly worth bearing in mind. And even if the application has been successful, there is I think, a great deal of uncertainty as to what is going to happen to the proceedings that happened before. Is there going, for instance, depending on the stage of the proceedings, are the new tribunal or the remaining arbitrators going to order a new hearing if a hearing has already happened? What is going to happen to the submissions that have been submitted to the previous tribunal comprising the challenged arbitrator? And all of those are very important considerations for you and your clients. And it may well be that having considered all of these, you decide against making the challenge, even though the prospects or a successful challenge are promising. Then we have the slightly less happy circumstances of an unsuccessful application, and there are a wide range of ramifications, both for your clients and for the existing arbitration. First and foremost, clearly, in the case of an unsuccessful challenge, the challenged arbitrator, will remain in post. Although they are supposed to put the challenge against them out of their minds when deciding the rest, going through, presiding over the rest of the arbitration proceedings and deciding the arbitration, this is often easier said than done. There's a real risk that the party's credibility may be damaged, such that going forwards, its substantive case is going to be viewed with a degree of skepticism, especially by the challenged arbitrator. This is especially the case where the challenge arbitration is viewed as an unjustified personal attack on the arbitrator himself, sort of exemplified by, for example, less polite, intemperate letters written to the arbitrator himself. if those things happen in those circumstances, there may well be a loss of goodwill from the tribunal, particularly the arbitrator who's being subject to the challenge. It is for that reason, I think, as always, impress on my clients and my colleagues, it is especially important that if a decision is made to mount the challenge, it is really very important to make sure that the challenge, the application, is pitched carefully to avoid situations in which perfectly legitimate concerns and valid questions about an arbitrator and his potential conflicts of interest are seen as personal attacks on the arbitrator. And a failed challenge may also be seen as a tactical move to cause delay and disruption to the proceedings. In some institutional arbitration rules, for example, the ICC, expressly empower the tribunal to take account of these conduct issues on the issue of costs. And then lastly, as I said, there will be the issue of costs, which are associated with a challenge. And the cost of a failed challenge will obviously be borne by the losing party. But there's also a question mark around the costs of a party who may be forced to defend an application challenging a tribunal member. So, as I said, on the whole, I would personally discourage tactical, opportunistic challenges against an arbitrator. But having said all that, those considerations should also be balanced against the need to make sure that concerns are raised promptly in a timely fashion. Because, as mentioned earlier, a failure to challenge an arbitrator may be considered a waiver of the arbitrator's conflict of interest, which then prevents the party from attempting to set aside or resisting enforcement of the award later on the same grounds. So all of these, all of these considerations, will require very careful balancing, unfortunately. And there's often no right or wrong solutions to this type of scenario. But it's important that everything's considered in the round before a decision is made to or not to challenge a particular arbitrator. And so, having heard me describe all of the difficulties that may be associated with making a challenge against an arbitrator, I want to just share some tips, some practical tips that I've found useful in practice. Firstly, I think it's it goes without saying that it's hugely important to do our research into the arbitrators or arbitrator candidates as soon as a name or names have been proposed by the institution or by your opponents. There are many ways where research can be done. For example, a sort of a simple desk search of sources such as Jus Mundi, which provides very sort of is a lot of detailed information about how individuals and practitioners are connected with each other, and that might be a very useful source of information. Speak to your colleagues, speak to practitioners that you're aware of. Take advantage, I think. I happen to work in a very large law firm with offices around the world, and it's I often I'm certainly I've sent very numerous emails around the firm's network asking for feedback on arbitrator candidates, and if you have a personal or a firm network, and it's I think it's certainly a good idea to take advantage of the wealth of knowledge that's there. Have a very detailed consideration of the grounds, whether you have solid grounds to make the challenge. Look at the IBA Guidelines, although those are not hard and fast rules. They are they're very popular and heavily adopted in arbitration proceedings. And I think it's important and it'd be very helpful to be familiar with the standards and tests that are set out in the IBA Guidelines. then I would encourage you to consider consider published decisions by sort of international arbitral institutions. Look at how decisions have been approached and decided by institutions, and consider where some institutions have come down on certain fact patterns, and make sure that you also you are on board with the fact that unfortunately it's very rare for a challenge for a challenged an arbitrator to succeed in an institutional context. Just by way of an example, the ICIA is in London is one of the few institutions to give reasons for its decisions on challenges. Between 2010 and 2017, they've published 50 digest decisions. Those 50 decisions represent 2% of 1,600 cases that were registered in that time period. And out of all of those cases and the 50 attempts, only 5 of those challenges were successful, which represents a success rate of just over 10%. In 2015, the ICC announced that it would now proceed reasoned decisions on its arbitrator challenges, but solely to the parties. There are some statistics on challenge decisions that for the decade between 2001 and 2011, which were published in the ICC Secretariat's Guide, commenting on the 2012 ICC rules. In that time period, 10-year time period, just under 400 challenges were filed, which represents 3.3% of all of the arbitrations that were filed in that period. And of those 397 challenges, only 30 were accepted, i.e. that's a proportion of 7.6%. So as you can see from these statistics, it is successful applications to challenge an arbitrator are really few and far between, and this is something that really needs to be borne in mind by all of us when we're considering making an application, because the odds are absolutely against us as counsel and parties, unless the fact patterns are absolutely overwhelming and the grounds are that you have solid grounds. I think that it is certainly worth being cautious about the prospects of a challenge. And I've put writing to the arbitrator on the side. Before an and I think this could be a very sensitive matter in practice, in writing to the arbitrator that you wish to challenge. Both before and after a decision has been taken to challenge that person. Once a decision has been made to challenge, the first step is, of course, to write to the arbitrator, usually copying the institution, and co-arbitrators to set out the facts, giving rise to your concerns. But before we even get there, I think a preliminary letter to the arbitrator can be a very useful tool for gathering information and gauging how strong your case may be in making the challenge. And that may be the occasion where you can ask questions regarding, for instance, sensitive questions regarding, for instance, the level of income that the arbitrator has derived from a certain party or from appointments from a party. Or there may be questions that you wish to ask about his dealings with a party or a stakeholder, for example, a third-party funder. Irrespective of what questions you would like answers to, it is important, and I cannot stress this enough, it is very important for the letter to be worded carefully. Professional, courteous, absolutely, no personal attacks, however egregious you consider the facts may be. And that will hopefully put you and your client in a good position going forwards in terms of deciding whether to go ahead with a challenge. If the arbitrator, the challenged arbitrator, and then the explanation, the response coming back from the challenged arbitrator may be a factor in deciding whether there are grounds for challenging him. And there are some cases in England which have decided exactly on that point. If an arbitrator refuses to provide information, the refusal itself can be useful evidence, as I said, which can be deployed later in the formal challenge application to support an inference that that arbitrator has significant, links, for example, with a party, and may actually be lacking independence or impartiality. In terms of making the application itself, I think it's useful to bear in mind that the object of such an application is to persuade a skeptical institution or the other arbitrators that they should intervene. It goes without saying that there will need to be very detailed explanations of the evidence for first and foremost giving rise to the grounds of challenge. But there will also need to be detailed explanations to why the application should succeed, why depending on the situation, why the institution or the court has the power to remove the challenged arbitrator. And all documents relied on in support of the application, whether it's include desktop and other research or other procedural decisions or correspondence will need to form part of that application. And then it may be useful to request an opportunity to respond to any submissions made by the arbitrator or the other party. And suggestions for the process, and make suggestions as to what process is appropriate to be followed in determining the application. The last point I want to make is in relation to responding to a challenge. In practice, this can be an awkward situation for you, maybe an awkward situation for you and your client, very much because unlike sort of adversarial proceedings, in this type of a challenge scenario, the target of the challenge is not the parties, but the arbitrator or the arbitrators. I think it's worth having a very careful think about how your client should be responding to a challenge directed at one of the tribunal. Of course, I think it's perfectly legitimate to make certain objections. Certain objections if, for instance, if the challenge is made out of time, if and that there may be no harm done at all, and those are perfectly legitimate. But it's useful to make sure that the response is careful and measured, particularly where allegations have been made against the arbitrator having links with one of the parties, i.e. your client. In order to avoid, it's a good idea to avoid an overly aggressive response, which may strengthen any impressions or your opponent has already had of inappropriate links between the challenged arbitrator and your client. Alternatively, you may decide to say very little or decline to comment altogether. Or indeed, you may agree with the challenging party that the arbitrator should be removed just for the sake of getting on with the arbitration proceedings, or to avoid a lengthy delay to minimize the risk to the integrity of the award. So all of those options are worth considering before you land on a particular cause. And it's important, again, to look at the circumstances very carefully and also the basis of the challenge to decide what is the most appropriate way forward. Conscious of time, I will say I'll go very briefly over the next two slides, which touch on the role of the national courts in the challenge against an arbitrator. as discussed earlier, national courts may play a role in challenging arbitrators, either as a decision maker first instance, in an ad hoc scenario where the parties have not agreed on another procedure, or after parties have exhausted an agreed procedure, typically when they're, where they're involved in an institutional arbitration. The sort of UNCITRAL model law, which has influenced the arbitration legislation in many jurisdictions around the world, the parties are free to agree on an applicable procedure for challenging an arbitrator. Under, as I mentioned, Article 13, if a challenge is made and is the challenging party is required to provide a written statement of reasons to the tribunal. And if the challenge is unsuccessful, then the challenging party may request within 30 days that the court or authority decide on the challenge, which is subject to no appeal. And then some examples of the approach taken by the English courts under the Arbitration Act 1996, as I've touched earlier, Section 24 provides the English courts with the power to remove arbitrators. This is a mandatory provision of the Act which cannot be contracted out of. And then the basis of the challenge concerns, as discussed earlier, justifiable doubts as to impartiality. And Section 24 under Section 24.2, if there is an arbitral or other institution already vested by the parties with power to remove the arbitrator, those avenues would have to be exhausted before the courts would entertain an application. And Section 24 then goes on to say, make further provisions on the challenge, which I won't go over in the interest of time. And lastly, just to give you some examples, I listed on this slide some of the cases that various jurisdictions have approached the issues of independence and impartiality. I don't propose to say an awful lot about this, save to say that I think in England and Wales, the Halliburton judgment is the leading case in English law, which the decision on arbitrator conflicts, and that decision has clarified how apparent bias will be assessed by the English courts, refining the test in the context of arbitration. The Supreme Court confirmed that the assessment of a fair-minded and informed observer of whether there is a real possibility of bias is an objective one, and that is the test, that is the crucial test for deciding whether there is an appearance of bias. And the court will assume that an informed arbitrator takes a balanced approach and appreciates the context that forms an important part of the information to be considered. And lastly, I just want to say sort of a very brief word about one of these cases, which was decided earlier this year, earlier this year, and it's the H1 and W 2024. And the reason I mention this one in particular is not only that it's a recent case, but it's also a rare example of a successful application under Section 24 of the Arbitration Act 1996. I think what's particularly interesting to me is that I think it demonstrates how very high the bar has been set for parties to overcome in order to get home on a successful challenge. In that case, a dispute arose between the film company and their insurer following a stunt scene which went wrong during filming in Sweden. The insurer rejected the claim and the parties went to arbitration. At a procedural hearing, the sole arbitrator, who was a film production professional, not a lawyer, made a number of statements about accepting evidence of the insured's experts. It was said that they knew the insured parties' experts extremely well, having worked with them closely in the film industry. the arbitrator would absolutely believe the insured party's evidence on particular issues, and that the arbitrator did not need to hear any of the expert witnesses, given that he already had sufficient, meaning the arbitrator, had already had sufficient knowledge about what was appropriate on the film set. And ultimately, he said he could say now what his decision would be. Some of you are laughing. It is very, very unusual, safe to say, that an arbitrator would make these comments and remarks, certainly in my experience, during the course of an arbitration hearing. But this is the facts that that were presented to the courts, and it's of course a very unique set of facts. The application, unsurprisingly, was granted by the court, holding that the arbitrator's very explicit remarks regarding his inclination not to accept certain evidence indicated a prejudgment of the case, and expressed the willingness to accept a party's evidence without even hearing it. And this really could lead a fair-minded, objective observer to conclude that there was a real possibility of bias. Hopefully, none of this is going to be surprising to any of us. But that really, I think, to my mind, goes to show how really very rare a successful application, is in this context, and what it actually takes for a party to be successful, both in the courts and increasingly in institutions, to get home on an application of this kind. And this is really what I hope to say on this topic. And I'd be very glad to take any questions if there are any. Alternatively, more than happy to talk to you over a quick drink or coffee.
Thank you for a very informative presentation. My name is Altair. I'm a law student at Durham University. My question to you is, since you're a legal director at DLA Piper, and DLA Piper is a huge firm with numerous partners and numerous clients, how do you avoid a conflict of interest when it comes to arbitration?
This is an excellent question. Thank you very much for raising it. I think it probably would be helpful to clarify, sort of in terms of whether you are asking about avoiding conflicts of interest in our work as counsel, or whether you are asking about avoiding or mitigating the risk of conflicts when individuals at the firm are being asked to sit on tribunals. But irrespective of which way it is, I think it's fair to say that large law firms such as DLA, with multiple offices around the world and lots and lots of practitioners in various practice groups, is a real issue and real source of conflicts. And it is particularly difficult, I think, when individuals, lawyers working at the firm, are approached to act as arbitrator. Because the reality is, however sophisticated and extensive sort of a law firm's conflict checking systems are, it is very difficult, I think, to be entirely thorough when it comes to verifying potential links. And I think in today's world, our clients and corporates are becoming ever so complex with their internal structures. And those structures are subject to a very frequent change in terms of mergers and reorganizations, internal organizations. So I think the short answer is it's very difficult, and it's precisely for that reason. My own sense is, although that nothing official has been said to me, but my own sense is that we are all, by we, I mean DLA lawyers, I'm certainly one, are discouraged from considering arbitrator appointments purely for that reason. Any more?
Well, thank you very much, first of all, for your presentation. My name is Almas Sirkola. Are there any guidelines on how many times an arbitrator should be appointed by another party, so that I'll have some justifiable doubts about his or her impartiality? And for example, 3 times, 5 times, in what kind of period of time?
Yeah, that's an excellent question again. Thank you for asking it. I think if you look at the IBA Guidelines, the recommendation is to look over back the last 3 years and look at how many references, how many appointments have been made. But I think I'm probably right in saying that there is no hard and fast rules of how many appointments there are. And if you look at some of the court's decisions, challenges are looked at on a case-by-case basis. And in addition to the number of times an individual has been appointed, other factors such as the overall income and the percentage of income deriving from those appointments, those are also very important considerations in deciding whether there's appearance of a bias. So in my preparation for this, I've looked at some of the cases, and they range from single-figure percentage to all the way to, say, a quarter, even approaching a third of an arbitrator's income deriving from repeated appointments. And I think it's fair to say that, certainly, sort of the higher the percentage, the more the appointments, and certainly the greater the risk of a successful challenge. But it would all have to come down to the facts. I see no hands up, so which brings me to say thank you very much for listening, and it's been a great pleasure.